Buckle up, because today's case is a roller coaster of broken promises, failed drug tests, and courtroom patience wearing thin. We're about to step into the world of Miss Gonzalez, a defendant who's been given second chances, third chances, and, well, let's just say a few more than most. The state is moving to revoke her community supervision. And the evidence? Let's just say it's a laundry list no defense attorney wants to read out loud. We got alcohol, pills, meth, cocaine, and that's before we even get to the skipped monitor and device logs. But the real twist? She's not going down without a fight, insisting it's all due to medical needs. So, is this a case of misunderstood pain management or a pattern of dangerous behavior? Let's dive in and see how the judge handles it.
Each of these, and so I'd like to be able to respond to them before the board if possible.
Sure.
Well, I would ask them to start with their motion though, actually.
So here's the deal.
Yes, Your Honor.
I have a lot of history with Miss Gonzalez, a ton of history you don't know about. And we've gone round and round with her testing positive for alcohol, pills, meth, cocaine, alcohol, and it's literally been over and over, and it's been over. And now while she's on this probation, she tests positive for meth.
The night she tested positive for amphetamines, meth, and opiates, and on the March 5th, she tested positive for THC. She's also had skips on her device, 12 in February, 5 in January, 8 in December.
Here's where things get serious and messy. Skipping monitoring device tests is like skipping school, except instead of a detention slip, you could end up in jail. And with 12 skips in February alone, plus failed drug tests for meth, opiates, and THC, the prosecution isn't painting a picture of an oops, I forgot moment. This is a pattern. The judge already warned Miss Gonzalez. Play by the rules or face treatment in custody. Remember, in probation, every missed test counts as a violation, and every violation pushes the court toward revocation. At this point, the state's patience isn't just thin, it's gone.
In terms of the treatment, Your Honor, is it that you are wanting it to be jail-based treatment, or could it be facility?
It's too late. We're helping ourselves to test casita. It's a 3 to 6 month program based on how to respond.
Your Honor, I have my father at home by himself, Your Honor,
Gave you the opportunity, ma'am.
May I speak to you openly? Just for a second, Your Honor?
No, I've heard it before. You've told it to me time and again, and I've heard it time and again. And I'm sorry, but we gave you the opportunity. You're testing positive for these.
Please. So, Your Honor, I think when I spoke to her before, the only thing that we were talking about in terms of possible failed drug tests was a test that I showed from last month for marijuana. And so her explanation for that, Your Honor, is that she has broken her arm in 2 different places and pain management issues. Until we were here now, I'm only hearing about these other things. The only reason I bring it up, Your Honor, is because if she is having some type of issue with substances, I support treatment. I just question whether the jail-based treatment is the only possible option. Like, could she go into custody and be transferred from there into a facility where she has to be inpatient for 120 days or however many days you're requiring? Does it just have to be who, I guess is what I'm asking.
Here's the thing. Every time that I've done a TRAS on someone and have deviated from it, we've paid for it dearly. They've either picked up a new WI, a felony, and I really take homage in the TRASs because I tell you, every time we deviate from it and I acquiesce to something that you guys want or defense wants, we pay for it dearly and they end up in a worse position. And so that's why this has been an ongoing battle for 2 years. We've had an ongoing battle with Ms. Gonzalez for 2 years where it's been nonstop testing for this or testing for that. And I can show you the proof. I've got the proof. And now while she's on bond, she picks up a felony PCS. She's testing positive.
Notice how the judge shuts down the idea of a softer, facility-based treatment? That's because he's been here before. Every time he deviates from the standard jail-based program, every time he gives someone a lighter path, they end up back in trouble, sometimes with new felony charges. Judges call this burn scars from past cases. It's why he's sticking to his process here, even when the defense argues for an inpatient program instead of jail. He's not just thinking about Miss Gonzalez's past. He's thinking about every defendant who's ever proved him right when he stuck to his strict methods.
I would just add the felony PCS was dismissed.
I get it.
It's my medication.
Within 5 days of it being filed. So
I understand. I get it. But I really want to do it with TRS. You know, I'm sorry, man, but that's what we're
I
going
can't
to do.
leave my father, sir.
These are things that you think about when you're out there in the free world. We gave you the opportunity, Ms. Gonzalez. I'm not going to argue with you.
No, sir, I'm not trying to argue with you, sir. I don't think the drug tests you're not, Your Honor, I'm so sorry. I'm not trying to say you're not looking at it correctly, but maybe you're not remembering, sir. I haven't
so
drank
maybe
in
she wants a
15 years.
motion.
You can hear the desperation in Miss Gonzalez's voice, mentioning her father, her sobriety from alcohol, and her belief that her test results are from prescribed medication. This is a crucial point in courtroom dynamics, sincerity versus credibility. The judge isn't dismissing her concerns outright, but he's balancing them against years of violations and repeated drug use. In legal terms, her mitigating factors, like caring for a dependent, are clashing hard with aggravating factors, like multiple failed tests. And when the aggravating outweighs the mitigating, judges lean towards stricter sentences.
Sir, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail to be probated for 18 months. Has he done the TRAS yet?
Yes, ma'am.
No. You will do what's called a TRAS. This is an evaluation to see what other conditions you may need. You must fulfill these conditions. If you don't, a motion to revoke will be filed. You will be put into custody, and we are going to have a hearing on whether to revoke your probation or not. It'll be DWI repeat offender education class, 2 victim impact panels, no drugs, no alcohol, no breath test refusal, meaning that if you're pulled over, an officer asks you to submit a breath test while you're on this probation, you must do it. A guardian interlock, 30 hours of community service, and 5 days in Harris County Jail as a condition. Is this how you understand it?
Yes, sir.
You know, the more important thing to me, Mr. Garcia Ibarra, is you're young. What are you, 35, 37?
I'll be 33.
Now we move to Mr. Garcia Ibarra, and this judge does not hold back. This isn't just about one DWI. It's about a history that includes fleeing police and assaulting an officer. Judges often use this moment to deliver a wake-up speech, hoping the defendant realizes how close they are to a long prison stretch. The warning here is clear. Next DWI, even if it's just for the smell of alcohol, could land him in the penitentiary. For repeat offenders, the law doesn't care if you're at the legal limit or not. Your record speaks louder than your breathalyzer.
Do you know what happens next time you get a DWI?
Yes.
What happens?
It's a felony in jail.
2 and in the penitentiary. That's what happens next time. And with your record, as bad as it is, it doesn't have to be where you're stumbling, stupid, fall-ass drunk on the road. The mere smell, in and of itself, they're going to look you up. Every single time you get pulled over, they're going to harass and harangue you. It doesn't matter what you're doing, what time of day, where you're going. Every time you get pulled over with your record, they're going to harass you. So why give them the evidence? Why give them, of all the aches and pains, 1 button and $50 anywhere you want to go in this life? Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, like I said, it'll go on your record. It will be there for the rest of your life. How do you plead to this offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty, and I'm going to sentence you to 1 year in jail. I'll probate that for 18 months. You will do a repeat offender DWI education class, 2 victim impact panels, guardian analog, no drugs, alcohol, 30 hours community service. Do you have any children?
Sorry.
If you do a parenting class, I will consider the community service waived.
This is where the judge gets strategic. If jail time won't get through to you, maybe your wallet will. A $6,000 surcharge with the warning that every $100 unpaid equals a day in jail is no joke. This is called a compliance incentive, and it's designed to make sure the defendant takes probation seriously. For someone with multiple DWIs, the court is sending a message: we're done playing games. It's also a reminder that probation isn't a free pass. It's a deal. Break it, and the full sentence is waiting.
I will give you plenty of time to pay for it. We will give you a 2-year to 3-year payment plan. So that will give you enough time. If you have any problems, you can come talk to us. But the worst possible thing you can do in this life is pick up another DWI, pick up another case, or abscond, take off. Because if you do that, that's just, it's a guaranteed motion to revoke. You understand?
Sorry.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I will find you guilty. I'm going to sentence you to this agreement. For what it's worth, I usually waive these on almost every first DWI. You're now working your third. So at some point, like I said, we've got to get a hold of you to ensure that you don't pick up a felony or kill someone.
I just want to mention that I was talking to him about his finances, and my intention was to ask you to waive it, and I understand
I
you've made your
normally
ruling.
do, Ms. Casanova, on all first, but this is a third alcohol contact. You know, I'll waive his supervisory fees with regard to them, but I want to get his attention. And I think that probably the only way to do it is with money. And like I said, if you don't pay it, your butt's going to sit $100 for 1 day in jail. You're probably going to owe somewhere in the neighborhood of
So
now.
what do we
You're
see
obviously
today?
not doing.
2 defendants,
The
2
other
sets of second
is
chances,
by hitting
and a
you where it
judge
really
who's clearly
hurts.
done
And that's
giving
what we're going to
leniency
do.
without
I'm now
accountability.
going to hit you with the
Ms.
surcharge that you
Gonzalez's
will be
repeated
required to pay.
violations sealed
And
her
if you don't
fate
pay it,
for jail-based
every
treatment.
$100
While Mr.
you owe,
Garcia
you
Ibarra
will
got
sit
a mix of
1 day
probation,
in jail.
education classes,
I don't know what
and a
else
hefty
we have
financial
to try to
penalty,
get your attention.
all
So
to
that
keep him
I'm
from a third strike
hoping
that could
that
land
this
him in
is it
prison.
before
These
you
cases
pick up a felony
highlight the
offense.
tightrope judges walk between rehabilitation
It's a
and protecting the
$6,000
public.
surcharge, and then how much
What do
your
you
court
think?
costs.
Was the judge too strict, or just doing what the law
When you're,
demands? If you found this case as shocking as we did, make
I
sure to
will
hit
give
that
you
like
plenty of
button,
time to pay
share your
for it.
thoughts
We
in the
will give you a
comments,
2-year
and
to
don't forget to
3-year payment
subscribe
plan.
for more
So
jaw-dropping
that will give you
courtroom
enough time.
breakdowns.
If you